This guideline is designed to assist you if, one, you want to file a lawsuit in the federal court, or you have an active role either as a plaintiff or defendant in a case that you or someone else has filed already in federal court. And two, you have elected to proceed with the assistance of a trained and licensed attorney. Some basic definitions that you need to be aware of regarding commonly used terms in civil action plaintiffs before this actions pending before this court are as follows. Plaintiff and defendant in court cases are generally referred to as the parties or litigants. The plaintiff accepts a claim or right protection by law. Plaintiff has a claim or right protected by law against the defendant. The defendant denies the claim or right, and the court determines whether the claim or right have substance or merit. The majority of the litigants who appear in the court are represented by an attorney who has been trained or in the law and is familiar with the applicable court rules and procedures. Plaintiff or litigants who are not represented by licensed attorneys who elect to represent themselves generally are referred to as pro se parties or pro se litigants, likewise plaintiff or defendant. Who represents themselves generally are referred to as pro se plaintiffs or pro se defendants. These guidelines will not answer all your questions about what you need to do to represent yourself efficiently as a pro se litigant. The guidelines outlined in basic steps that are required to properly file a civil action or lawsuit with this court, as also provide some general guidance on the next step in the processes of litigating the action once you have filed it with the clerk of court, whomever you are representing for learning about and following the processes that govern the court processes. Although the staff or the clerk offices can provide pro se litigants with general information concerning court rules and processes, they are forbidden as a member of law from providing legal advice, from interpreting and applying court rules, or otherwise participating directly or indirectly in any action. A word of caution: self-representation carries certain responsibilities and risks that pro se litigants should be aware of before they proceed. The court encourages all individuals who thinking about proceeding pro se or engaging in self-representation to carefully review the risk associated with self-representation and to inform themselves of the potential consequences. Warning: Rule 11 of the Federal Rules of Civil Procedure prohibits the filing of lawsuits that are clearly felonious or filed merely to harass someone. If after reviewing your complaint the court determines that you have filed a lawsuit for an improper or clearly unnecessary purpose, it may impose sanctions against you, including order you to pay legal fees of the person or persons against whom you have filed a lawsuit. In other words, if it doesn't impact you and you're just razzing them, Section 8. Section 1. Important issues you should consider before deciding to represent yourself in an action before the federal court. Is the federal court the appropriate court to hear your dispute? The United States District Court of the Western District of North Carolina is one of 194 trial courts in the federal court system. In the state of North Carolina, there are 3 United States District Court, which are the Eastern, Middle, and Western districts. Each district is divided by counties in which it is sanctuary comprised. Startingly comprised. Okay. I'd have to look that up on Google. I'm not going to pause you to do that. The United States District Court of the Western District of North Carolina is divided into 3 divisions: Asheville, Charlotte, and Statesville. These divisions are comprised by the county as follows. Okay, that's all for us. And we are supposed to be right here in Watauga, and we're in Statesville. The clerk's staff office the clerk's staffed office located in the city of Asheville, Charlotte, and Statesville are available to accept and file new lawsuits pending holding court processes and carry out the assigned duties and businesses of the court during the hours of 8 a.m. to 12:30, from 1:30 to 4, Monday through Friday. Is there a alternative to appearing pro se, representing yourself, that is affordable? Most people who file and pursue litigation in the federal court employ a licensed attorney who, for say law, has appeared in court and is familiar with the rules of procedure that govern the court processes. If you would prefer to have an attorney to represent you, but you are unable to afford one, you should consider contacting the local bar association, whose staff can explain the various options for obtaining and paying for legal services. If you cannot find an attorney to represent you, you have the right to pursue your claim in the court by appearing pro se. Be aware that appearing pro se litigants, you are representing only yourself and proceeding only your claim or defense. Under the law, you cannot speak for another person, a company, or other entity such as a club or association that includes otherwise individuals. When you appear pro se, you must follow the same rules and procedures that licensed attorneys who participate in the court must follow. Generally, judges hold pro se litigants to the same standards of pro se responsibility of trained attorneys. If you plan to represent yourself, where can you go to review this court rule for pro se and applicable federal lawsuits? I guess this is it. As a pro se litigant, you should be familiar with the applicable state of federal rules of procedure. These rules set forth the guidelines, the general procedural requirements for litigate's case in all federal courts. As a pro se litigant in a civil case, you should be familiar with the federal rules of civil procedures and the federal rules of evidence. If you are a pro se defendant in a criminal case, you should be familiar with the federal rules of procedure and federal rules of evidence. Federal rules are located in the U.S. Code, which avails as USC. These laws could be applicable in your local public or county government library. As pro se litigants, you should be familiar with the district court rules of prudence, commonly referred to as the local rule, which applies especially to the court proceeding in the court. The local rules covered in the general proceeds of the action filed in the Western District of North Carolina. The local rules can be reviewed by a public law library and are located in the North Carolina Rules of Court. Federal published. The North Carolina Rules of Court. Federal published by West Publishing, or the alternate rules of North Carolina available in the North Carolina statute published by MICHIE, Michael Mitchell. The local rules are available for purchase in each of the clerk staff's office for a fee of $10 or can be downloaded at no charge from the clerk's website. The website can also be used to obtain, it's got a website, www.ncwd.uscourts.gov. The website can also be used to obtain forms, reviewed cases, dockets, and obtain directions to all courthouses locations within your district. How to start a new case. File a complaint. The plaintiff or person bringing the lawsuit to court files a complaint. Simple complaint forms are available. Plaintiffs are lawsuit filers. Simple complaint forms are available on the court website as well as in each divisional office. Your complaint may be typed or handwritten. You should make sure that your complaint is legible and can be easily read by the judge. The complaint can be filed by hand, delivering it to or mailing it to any of the clerk's staff offices in the district. The address and phone number for each staff office are as follows. Western District, 828-771-7200. That's Asheville. Charlotte, 704-350-7402. Statesville, 704-883-1000. The case will be filed and assigned to the correct divisional office regardless of which office receives the complaint for filing. This case assignment is determined in the Western District of North Carolina as stated previously in Section 1 and is based on the defendant's county of residence or the place where the incident is alleged to have occurred. Whether you deliver or email the complaint to the court, you must submit the original of the complaint along with whether you deliver or email your complaint to the court, you must submit the original of the complaint along with any copies you would like returned enclosed in a self-addressed postage paid envelope for any copies you have included for return. The $400 filing fee, unless you are proceeding in a formal plenary as discussed in sections 1 and the guidelines. The complaint outlines a problem or reason for the lawsuit, also known as the case of action. This complaint is given a case number and assigned to the district judge. Several complaints in each defendant or persons whom the plaintiff claims is responsible for the problem must be notified of the lawsuit through a process that is specified under law. The responsibility for notifying each defendant rests with the plaintiff and is referred to as service of procedure. So, in other words, you got to make a copy for everybody that you're alleging. The provisions for the service of procedure are described in Rule 4 of the Federal Rules of Civil Procedure. If the service of procedure requirements are not followed, certainly the case can be dismissed for failure to effect proper services of procedure. The summons must be served on each defendant along with a copy of the complaint. You can obtain the standard summons from the clerk's office or the clerk's website. After you complete this summons form, clerk staff will officially issue the summons. This means that you are authorized. Court employees will sign the form. This means that an authorized court employee will sign the form and emboss it with the official seal of the court. File and serve the response. Once the defendant has been served with an summons, a copy of the complaint, the defendant must file with the court an answer or some other response within the specified number of days. Under the rules service of procedure, each defendant is required to provide a copy of the response to the plaintiff. Once each defendant has filed a response in the case, it is considered at issue. Once the case is at issue, you will be given an opportunity to participate in the WDNC Pro Se Settlement Assistance Program. Through the program, volunteer attorneys provide free legal assistance to Pro Se regarding settlements for their cases. The potential violators attorneys, who is appointed by the judge, proceed over the case, will assist you in preparing for the settlement conference, and will participate in the settlement conference with you. While the assistance that is provided by the program attorneys is free, you will be required to pay a portion of the cost of mitigation, including the mitigation fee, unless the court determines that you are diligent or you reach some other agreement with the other parties or plaintiffs to your case regarding payment of these issues. If a settlement is reached, the volunteer attorneys will assign in drafting a statement, agreement, and order document that may need to be filed with the clerk in order to close the case. If the settlement is reached after the litigant effects, the volunteer attorney participation in the case will end. Your participation in the program is evidently voluntarily. Once the case is at issue, the clerk will send you a form asking whether you wish to participate in the program. You will only be assigned a volunteer attorney if you choose to participate in the program, and return the form to the clerk's office within 14 days. Forms from the date in which you receive it. If you choose not to participate, you may still be required to attend the settlement conference as directed by the court. If your case does not settle through the program, or if you choose not to participate in the program, your case will proceed to a pre-trial conference. Local Civil Rule 16.1 governs that pre-trial conferences procedures for this district. You and the other parties, with and without attorneys, are required to confer as provided by law, Federal Rule of Civil Procedures. Open, plaintiff, then the defense, and then closing statement. Or something. You and the other parties, with and without attorneys, are required to confer as per Federal Rules of Civil Procedures 26F and conduct an until attorneys conference within 14 days of adjourned of the issue. Within 14 days of adjourned of the issues. Within 7 days of the conference, the parties shall complete and file the certification of intentional attorneys conference forms, which shall include a proposed discovery plan. Proposed discovery plan. That's important. I gotta do that. Proposed discovery plan. A conference served as the guidelines for the court and issuing a scheduled order once the constitution of intentional attorney conference forms has been filed. The assigned judge will enter an pre-trial order unless the parties request a pre-trial conference with the court. If requested, the parties' conference should be held within 14 days as of the filing of the discovery plan. Once the scheduled order is in place, then the case may proceed in accordance with the deadline established within the order of the Federal Rules of Civil Procedure. Civil case assigned to district judges. Your case will be assigned to a district judge under the authority of Local Civil Rule 7.1. Your case also could be referred to an magistrate judge for assistance in managing the case and coordinating certain procedures, motions for discovery and stuff. You have the opportunity to consent to judiciation of the magistrate judge to manage and hear all proceedings on your case, including federal filed dispositions of your claims. At case opening, a package will be provided to you which will contain a form entitled Notice, Consent, and Refusal of a Civil Action to a Magistrate Judge. The case will be reassigned to the Magistrate Judge only if all parties consent. The notice, consent, and reference of a civil action to a Magistrate Judge from form should be served on a defendant along with the services of a summons and complaint as set forth in Local Rule 7. Filing a motion to an objection, either parties, the plaintiff or defendant, may request that the court take specific action related to the case. To do so, the parties prepares a form request or what is referred to as a motion. As governed by the Rule 7 of the Federal Rule of Civil Procedure during the LR 7.1.v, parties must assign the motion and submit it for filing to the clerk of court. A copy of the motion must also be sent to the opposing parties or parties' attorneys. The opposing parties may file with the clerk of court an option or response to the motion. This response sets forth the opposing parties' reason why the court should deny rather than grant the motion. The time within which the response or reply to the motion is set out by LR 7.1. That the deadline for the filing of a motion with a civil action is generally set out in the potential order. motion review, the district judge or magistrate judge may schedule a hearing on the motion, or the judge may decide the motion without a hearing by issuing a written order that either grants, denies, or potentially grants or denies what the motion sought. The dispositive versus non-dispositive motions. Depositive versus non-depositive motions. I'm going to Google them two words. Dispositive and non-dispositive motions. Motions fall into two broad categories. Dispositive and non-positive. Dispositive motions, if granted, dispose of the case. Non-dispositive motions, if granted, affect the case but do not dispose of it. Direct judgment have the attorney authority to rule on both kinds of motions. Magistrate judges are authorized to rule only on non-dispositive motions on case referred to him by district judges. If the parties have conceded to jurisdiction of the magistrate judge as the presiding judge, the judge to whom the case is assigned, then the magistrate judge has full authority to rule on both kinds of motions, the same as the district judge. Magistrate judge more or random and recommittation. Magistrate judge memorandum and recommendations. If a dispositive motion is filed in a case and referred to a magistrate judge, the magistrate judge is authorized to prepare a written memorandum and recommendations recommending that the motion be either granted or denied, and state the reason why. The memorandum or recommendation is filed on the case docket, served electronically on the district judges assigned to the case counsel of records, and mailed to the pro se litigant as a party. You have a certain number of days within which to file objections to the memorandum and recommendations. All objections that are filed within the specific time are reviewed by the district judge along with the memorandum and recommendations. The district judge will issue an order that adopts, rejects, or adopts. In part and rejects in part the magistrate judge memorandum and recommendations. In the event that the judge's order dismissed the complaint and the cause of action, the clerk of the court will prepare and enter a judgment in the case. Such judgment is filed and can be appealed only to the U.S. Court of Appeals for the Fourth Circuit local in Richmond, Virginia. What court fees and court costs are required? The fee for filing must civil action in any U.S. District Courts 402. This may be paid in cash to clerk blah blah blah. That's blah blah blah. If you are unable to pay the filing fee, you may apply for permission to proceed in. Oh, I have to look this up. Proceed in formal progress. Means you broke ass. Right? Where was it? Plead with the court in person. How do I submit documents to the clerk? Informal progress is available at each of the clerk's office or forms. The website at complete applications are filed and reviewed by either a pro se lawyer, clerk, or magistrate judge. If your application is denied, your case cannot proceed until you fulfill the fees is paid. Unless the clerk orders otherwise, at the time of ruling on the pro se application, waiver of the filing fee made by the clerk does not automatically waiver the other costs associated with the pursuit of litigant in your case. For example, if you need, if you need copies or documents, 50 cents per page. Documents you filed with the clerk, mailing and hand delivering a copy of each document and the applicant parties to satisfy the required statements. How do you submit documents? The court required pro se parties to submit or file a original of each party form. Scan the image, blah blah blah. how do you obtain information about the status of a proceeding of your case? Is it the responsibility for you to speak directly to a judge or member of the personal staff about your case? As a party appearing pro se, you are prohibited from all private or ex parte communications with the judge to whom your case is assigned. Ex parte communications occurs when one of the parties to the lawsuit exchanges information with the assigned judge without the opposing parties being present. I know! That's why the Board of Education meeting people can't go into the judge's chambers like they do, but the state board seems to think they can.
What I just read.
I want her to be willing to, but I don't want her to have to.